Good afternoon, everybody. Thank you for attending today's session on fair housing. Just a couple of reminders before we get started. Please keep your microphones and cameras off to eliminate distraction. Also, if you have questions, please type them in the chat box and I will relay them to our presenter as we go along. And lastly, there will be a survey that is sent out at the end of the presentation. Please provide any feedback and possible topics that you would like presented on. We have one more session after today, and then we will be working on our spring session. So any topics are welcome. With that, I will turn it over to Kiersten.
Thanks, Kylie. So my name's Kiersten Small. I am an investigator with the department. I have been here a little bit over 10 years now, done a lot of different types of investigations, done a lot of wage and hour investigations, a lot of employment and kind of public service, public accommodation, discrimination investigations, and a lot of what we'll talk about today, which is housing discrimination. I have done a lot of the presentations with the department, so hopefully it's a long presentation. There's a lot of information, but hopefully it's something that you guys all gain something from, get some new information, or just kind of reiterate some of the information that you already know. And as we go along, we can certainly pop any questions into the chat, but we'll also have an opportunity there at the end to go through everything. So just to kind of talk through what we're going to talk about today. So first and foremost, we're going to talk a little bit about the department itself. Kind of what does the department handle? I know for myself, before I worked at the department, I really didn't have really any idea of what they handled, what they covered. And so we'll talk a little bit about that. We'll talk about what is housing discrimination. So obviously the fair housing laws are established to prevent housing discrimination. And so we'll talk through what exactly does that mean? What is housing discrimination and how does it impact us? We'll talk about those fair housing laws. We'll talk a little bit about those statistics and facts. So basically the numbers behind the kind of complaints that we see at the department. And then that'll lead us right into those common issues. So obviously those most frequently filed on issues, just common issues that we see or deal with the department. And then we'll talk about a little bit of best practices for going forward. Again, hopefully it's just kind of reiterating some of the information you guys already know. If not, hopefully you guys will gather something as far as kind of how to keep an eye out for housing discrimination and how to prevent it. So a little bit about the department itself. So the Department of Labor, it actually started as part of the Department of Ag. We are an extremely small agency. So it is a cabinet agency. So it's under the governor's office. And our commissioner is somebody who is selected by the governor and is appointed into that position. But we have a total of 7 investigators, and that is investigations for the entire state of North Dakota. So again, we handle the wage and hour division, the human rights division, and then this education and awareness. But the 7 investigators, they cover all of the investigations for all of the cases that are filed within North Dakota. We also have an administrative assistant. So she kind of helps run the deck as far as kind of the filings, openings, that type of thing. And then we have a human rights director who oversees all of the investigators. We have a director of operations, and then obviously the commissioner. So again, extremely small staff, given the fact that we do handle so many different types of cases, but small but mighty, I guess, is what you might say. Again, we handle kind of 3 main areas or 3 main pillars. The wage and hour division, that is, we'll talk a little bit more about that, but obviously it's kind of self-explanatory. It's about wages. It's about money with your paycheck, deductions, paid time off, that type of thing. Then we have the Human Rights Division, which we will be talking about the most today. That's the discrimination side of things. So it's discrimination in the employment, public service, and public accommodation, and then housing discrimination as well. And then the last pillar or kind of piece of what our department handles is the education and awareness piece. So one of our big proponents is that we obviously want the public to be knowledgeable in what the laws are and hopefully how to prevent them. So we are a neutral agency, which means that we're not on the claimant's behalf, we're not on the respondent's behalf. We are just truly a neutral party. But by providing all of that information to the parties, providing brochures, these type of events where you have kind of an educational setting. We do a number of different booths. We do a lot of just kind of general public outreach, but hopefully it obviously prevents issues from happening in the first place, but it also provides knowledge to both employers and employees as far as kind of what their rights are under our laws. So under the Human Rights Division, again, it's kind of the main sectors of it is the employment discrimination, housing discrimination, public service or public accommodation, and then there's also credit transactions. Under the Human Rights Act, that is going to be where most of our laws kind of fall under as far as the discrimination side. When we talk about the numbers a little bit, we see more complaints with the discrimination in employment side of things than anything. And then thereafter would be housing. But the Human Rights Act, that's going to contain all of the discrimination laws for the employment discrimination, employment retaliation, as well as those public service and public accommodation complaints. And then the North Dakota Housing Discrimination Act, this is the one we're going to be talking about the most today. Again, pretty self-explanatory. It is discrimination in housing. And then those last two laws, those are specifically related to our retaliation provisions. So we do have some retaliation provisions under the Human Rights Act. Basically, if you, let's say in the workplace, an employee reports some sort of sexual harassment, they do an investigation, and then as a result of that person reporting sexual harassment, they are retaliated against. So that's kind of the employment discrimination retaliation. That's going to fall under that Human Rights Act. But the whistleblower is a little bit different in the fact that I reported some sort of law violation. So maybe I reported that they're not following DOT requirements, or maybe I'm indicating that they're not following the licensing requirements for being an insurance provider or something of the sort. And because I reported that, then I was retaliated against. That would be a whistleblower law. So we do have some provisions with regards to that. And then lastly, that is specifically for public employees. And it's a pretty defined piece of the law, which basically says that if a public employee reported some sort of law violation in writing to their agency head, to the Attorney General's office, or a few specific individuals, that if they were retaliated against, then they could file with our department. So those are the pieces of the laws under the Human Rights Division. Just briefly for the wage and hour, again, it's pretty self-explanatory. It's for wages. So we see a lot with wages for work performed, hours of work issues, youth employment. So there's provisions in the state that if an employee is 14 or 15 years old, they are limited on hours or duties that they can perform in the workplace. And so that's covered under those wage and hour laws. We do evaluations for independent contractors to determine if they are truly an independent contractor or if they are an employee-employer relationship, so we can do those evaluations. Sub-minimum wage, so there's some employees that basically qualify to be paid less than the minimum wage of $7.25 per hour, but they do have to be certified to do so, and so we handle those applications and those certificates, and then employment agency licensing as well. Really, the thing we see the most with the wage and hour division, though, is payment for wages. So I wasn't paid properly. I wasn't paid at all. I wasn't paid for hours worked. I was exempt and I shouldn't have been, or vice versa. I didn't get paid for vacation time when I left employment or deductions from pay. Those are really the main issues that we see. So the wage and hour statistics, just talking kind of about cases that we have filed. Again, this is kind of why I mentioned how small of a team we have. And this is why really it does take quite a while sometimes to get cases assigned out. It's just really a sheer manpower issue. So when we look at the wage and hour stats, this is for the last biennium. So we actually just finished up and put our report out for the current biennium yesterday. But the last biennium, we had 722 wage and hour cases filed, 400 692 cases closed. And for this most recent biennium, we have 578 cases that were filed, 719 that were closed. So sometimes, especially being here as long as I have, you really get to see those ebbs and flows in cases where sometimes, obviously, during the oil boom, we had a huge influx of cases. Sometimes if a number of businesses go out of business or new businesses come to the state, we see a lot more or a lot less wage claims filed. And so we're always trying to kind of catch up on that backlog and make sure that we are closing more cases than were filed, but it can kind of seem as if we're always trying to catch up, just in the fact that it does ebb and flow quite a bit. So the human rights side of things, again, this is what we're going to be talking about the most today. Just kind of an overview again of those human rights issues. We handled the employment discrimination is going to be by far the most filed on issue in our department, followed by the housing discrimination. But we also handle what we call public service and public accommodation discrimination. So an example of a public service might be, let's say you are receiving services from the city water department or the police department, and you believe that they were discriminatory in the way that the services were provided, they have a right to file with our department under a public service complaint. For public accommodation, very similar to a public service complaint, kind of the same evaluation, but instead of being a public service, it would be something like a restaurant or a business, maybe like a Walmart or a boutique or something of the sort, that they're seeking some sort of services and goods from, and that would be a public accommodation complaint. Credit transactions. Sometimes we see credit transactions filed separately, and occasionally we see it kind of filed in conjunction with a housing discrimination because it's related to kind of that discrimination in lending. And so it could be like mortgage discrimination, or they're not being allowed a loan because of a certain protected category, in a sort of discrimination in that credit transaction realm. We don't see very many complaints of credit transaction within our state. And I think a big piece of that is obviously there's some other avenues that they can take. And so I think sometimes they take those other avenues as opposed to filing with our department. But we just don't see very many of those. And then again, housing discrimination, which we will talk the most about today. So just kind of comparison wise to those wage and hour complaints, as you can see, we have a lot less cases that are filed under the human rights side of things. This is again for that 2021-2023 biennium, 432 cases that were filed, 333 cases that were closed, and then 567 cases filed, 575 cases closed. Again, a majority of these were filed under that employment discrimination. But we'll talk a little bit at least about the specific housing numbers here in a second. But like I said, as you can see, we have kind of a substantially more wage claims. But even within just for the discrimination side of things, the human rights side of things, we do see quite a few cases every year of allegations of discrimination within the state. So obviously, we're here to talk about fair housing. We're talking about kind of what that means, what that looks like. So what is housing discrimination? Discrimination is one of those words. We see a lot of these different types of words in this Human Rights Act, in the discrimination realm of things. Discrimination, different meanings to different people. And certainly some people may have a different opinion of kind of what discrimination means, what that looks like. Same with harassment or, being treated differently. It just may look different to different people. Under the law, it is treating someone differently in the sale or rental of housing because of a person's membership in a protected category. So that is when we are looking at and evaluating a case that's filed with our department. This is kind of that baseline evaluation that we have to do. So is the person alleging that they're being treated differently in the sale or rental of housing because of their membership in a protected category? So we'll talk a little bit more about what a protected category is, because although, everybody may fall within a protected categories don't necessarily cover all aspects of what allegations might stem from. So the main pieces of the law that are under that housing discrimination kind of umbrella is the Fair Housing Act of 1968. So this is going to be the federal law. This is when you think of HUD, this is going to be kind of that federal side of things. Really, it has kind of expanded since its inception in 1968. There's been a lot of changes to it, but generally it just is covering any sort of housing discrimination, again, in that sale or rental realm. And then the North Dakota law is that North Dakota Housing Discrimination Act of 1999. This one is the one that we have, again, on the state side of things. Really, we have to have the bare minimum of having a substantially equivalent law to the federal law. And so basically, what that means is that we would have the fair, so we evaluate the law very similar or the same as HUD's federal law. So really it's very similar. We'll talk a little bit about what some of the differences as far as the law, our state law can go above and beyond what the federal law is, but it really has to have the very bare minimum of having a substantial equivalency to that federal Fair Housing Act. So, what do the fair housing laws do? So, why do we even have those laws in existence? Obviously, to combat that housing discrimination. So, it's to make it unlawful to treat someone differently because of in that sale or rental of housing because of their membership in a protected category. So, basically, to prevent the act of any sort of housing discrimination. So when we talk about those protected categories, these are the protected categories on the federal side of things, so that Fair Housing Act. The race, familial status, national origin, color, religion, disability, and sex, all of those do fall under the, again, Fair Housing Act. So this is that bare minimum of having those federal protected categories. But we can have additional coverages within the state in which we do. And that is the receipt of public assistance, domestic violence, age, and marital status. So we do have some additional protected categories within the state. Basically, what that means is that, again, we have to have those bare minimum of having those protected categories that are on the federal side. But over time, different legislative measures, changes, they can add additional protections. So within North Dakota, it is against the law to discriminate against somebody because of their receipt of public assistance. So the receipt of public assistance, obviously, it's pretty self-explanatory. If you're receiving some kind of financial public assistance, there are some pieces that may or may not fall under it as far as kind of what the assistance is, what type of assistance it is, but you cannot be discriminated against because of that receipt of public assistance. The domestic violence, this one's our newest protected category, and this one it's very specific. So it's individuals who are under some sort of state program that are victims of domestic violence. So they do have to kind of qualify in the receipt or as far as having the state program that they're within, but that is one of the newest coverages we have. Age would be any age 40 and over. So the age one, it actually is a federal protected category under employment. And so it's kind of something that we just added additionally to have within the state because it is already something that's a federal coverage. And then the marital status, that's again an additional coverage. Basically, it means that an individual can't be discriminated against because they are married, because they're divorced, because they're separated. So based on their marital status. We don't see a ton of cases that are filed on the marital status, but again, it's something that is a protected category. So when we talk about who or what is covered, so when somebody files, we're going to look at first and foremost, is the aggrieved person a member in a protected category? And are there allegations based on that? So are they saying, I believe I was not rented to because of the color of my shoes, or because I have curly hair, or is it because of one of those protected categories? And so that's something that we would be looking at kind of first and foremost is the individual themselves covered? Is the dwelling or the housing related transaction covered? So is it a rental, a sale, or other? So obviously it can be something like a discriminatory statement or advertisement, which we'll talk a little bit more about. But is the housing related transaction or the dwelling itself? So are there exemptions because of what kind of dwelling it is? So those are things that we kind of look at first and foremost as well. And then is the respondent covered under the laws? So are they exempt under any of the exemptions? Which brings us to, are there exemptions from the law? And so when we're looking at the exemptions, there are exemptions from the law. So there are basically kind of provisions out there that indicate that you really, it's not that yes, you can discriminate, but you're not covered under the same fair housing laws if, for example, you have a Mrs. Murphy's exemption. So if there's four or fewer rental units and the owner lives within one of those units, then you can be qualified as being exempt under the Mrs. Murphy law. So you wouldn't have the same ability to file a complaint. Or have those discriminatory actions, kind of the backing, if you live in one of those units. The four or fewer rental units and the owner living in one of those units, it is very specific that the owner has to live within the unit. So if it's a fourplex and let's say the owner's son who manages the property, watches everything, he's the one that lives within the unit. If it's not the owner, that would be something that we'd have to obviously evaluate because it would fall under one of those exemptions if the owner lived within the unit. Religious exemptions. So there are some exemptions for religious discrimination, but those religious organizations, they still cannot discriminate on the basis of race, color, or national origin. So although maybe they have religious pieces. So they state, you have to have a specific religious background, or maybe you have to, for example, be like married, or you have to be of a certain class of people. You still cannot discriminate on that basis of race, color, or national origin. Private clubs, very similar to religious organizations, and that's going to be the race, color, or national origin they cannot discriminate against, but they can under those other protected categories. So it's something like a members only type of thing. And then elderly housing exemptions. So this one's going to have some exemptions for basically maybe you have limitations due to the familial status or the age for the certain developments. So kind of those housing for older persons, those areas that maybe it's 55 plus, and they may have some of those additional limitations. So they could fall under those exemptions, even though maybe they're saying you can't have, a certain like a family status. You can't have young children in the unit or something of the sort, even though on the surface that may be discriminatory. If they fall under that exemption, then they would be exempt from those provisions. So now we'll talk about the statistics and facts a little bit. And when we're talking about these numbers, looking specifically at the housing cases. And so obviously we kind of talked through what the housing or the human rights discrimination pieces were, but now we're going to talk specifically related to housing only. So these are the last biennium complaints that kind of far column, that is the last biennium. So I put our newest numbers as well as last season's numbers of sorts. These are the types of cases that we had, how they were closed. So we'll talk more obviously about what types of cases were filed, but when we're looking at the cases that were closed in this last biennium, we had about 59 total cases that were filed, 20 of those resolved through conciliation, or basically coming to some sort of resolution with the department as kind of a mediator or the middle party and having an agreement through the department. 30 of those cases that we had that were closed were what we call no reasonable cause, which means that based on the facts and evidence, we do not believe a violation of the law occurred. Two of the cases that were closed were no or reasonable cause, which means we do believe that there was reasonable cause that a violation did occur. We didn't have any cases that were dismissed or referred to HUD, but that's always kind of an option of sorts or type of case closure. And when we talk about dismissed, it might be dismissed for various reasons. We have very specific reasonings as far as like we have to make certain amounts of contacts with parties before we close a complaint. We have to have a certain number of attempts. We have to contact them by different phone numbers, maybe contact their witnesses. And so maybe it might be dismissed because we're unable to contact the individual. Maybe it's dismissed because during the investigation, we determined that the housing related transaction was not something that fell under our law or that we didn't have jurisdiction over. So it could be dismissed for various reasons, but we don't see it all too often. Referred to HUD, it might be a case that maybe HUD is working through a number of investigations for that same respondent, or maybe it's just a specific type of case that is being requested to go to HUD, or HUD is requesting to have that case sent to them. And so it might be a number of different reasons as why a case might be transferred or referred to HUD. Withdrawn with resolution and without resolution. We had 5 this last biennium withdrawn with resolution. That basically means that the claimant contacted us and for whatever reason, maybe it's, hey, I talked to the respondent and we were able to work it out ourselves. Maybe it was, once I filed, they had actually gotten back to me before, I was able to not file the complaint. I filed the complaint, then they contacted me before they even got the complaint sent to them. It is resolved. So it's basically the complainant saying, yes, we came to a resolution, all is well. We don't want to move forward with the investigation of the complaint. Withdrawn without resolution, again, very similar. The claimant has to be the one that decides to withdraw the complaint. And it would be, let's say, maybe they moved and they said, I don't want to go through this anymore. I've moved to a different place. I'm kind of moving on. I don't need to continue to move forward with it. I just want to withdraw the case. So that could be withdrawn without resolution. Again, if you kind of look at the numbers in comparison to last biennium's numbers, we did have more cases that were filed. And when you kind of look at these lower numbers, these case numbers in the 40s and 50s, it is a pretty substantial increase from the last biennium. But case types of how they were resolved, somewhat similar. We did have a little bit more on the cases that were conciliated the last biennium versus this biennium. It just seems to kind of, again, ebb and flow. Just we sometimes see seasons or kind of different scenarios where we see a lot more cases that are resolving. And then other times we just may have cases that, no, we would just like to move forward at the investigation. We just want to move forward to having you guys make a determination. And so we see those numbers kind of go back and forth. So when we talk about the kinds of cases, how they were filed. So again, this is for the biennium that we just released a report on, this last one that ended at the end of June. And of the cases that we had filed, so of those 59 cases, 42 cases were filed with the basis of disability. When you look at these numbers, obviously you're going to see there's substantially more than the 59 cases, but it's because a number of cases may be filed on multiple bases. So maybe they are having allegations that they're being discriminated against based on their race, their color, and they were retaliated against. So you may have three bases, even though you only have one complaint. So when you're looking at those numbers, that's why there's obviously more than the amount of cases. But as you look at these numbers, 42 of them were filed on the basis of disability. The next lowest number was 12 out retaliation. So you can kind of guess where we're going with a lot of those common issues and talking a little bit more about what we see frequently as violated issues, filed on issues. And so when we talk about the disability, you'll see why we come, kind of, I guess, guns blazing, talking so much about disability. It's because it's by far our most filed on issue. We had 12 that were filed on retaliation, 11 on race, 9 on that receipt of public assistance, which again was a state only protected category, 7 familial status, 3 national origin, 3 color, 2 religion, 2 sex, 1 age, and 1 marital status. So just a breakdown, like I said, of those cases that we did have filed. When we're talking about the issue of disability, of these 42 cases, the vast majority, as in about 90 or more percent, were filed on the issue of reasonable accommodation. So when we look at disability, by far we see the most issues with reasonable accommodation. So it's something that we will talk about quite a bit. Just in comparison to that last biennium, again, 28 of them were filed on disability. Next one down was 10 with the receipt of public assistance. So, a little bit less on the retaliation front, but by far the most filed on was disability. And again, we nearly doubled that amount for that next biennium of disability related filings. So, that being said, we'll dive right into talking about what disability is. So, again, this is kind of where I always say there's different people have different interpretations or definitions for some of these issues. Lots of people have different definitions for discrimination, for harassment. Disability is one that there's a lot of information about what disability is. There may be people that qualify as being a person with a disability under SSDI. Maybe they are, through their employer, they're on short-term or long-term disability benefits. Maybe they have been classified under the VA as being a totally disabled veteran or something of the sort. So these are all different types of evaluation of what a disability is. For our purposes, so for that Federal Fair Housing Act, as well as our department's evaluation of it, we have to look at the legal definition of what a person with a disability is under that Fair Housing Act, and then again, that North Dakota Housing Discrimination Act. So that's when we're talking about whether or not a person is a person with a disability. They very much may qualify as being a person with a disability under other classifications, but it may not necessarily meet that evaluation under our law. So we have to look at whether or not an individual meets that definition because the individual has to have a physical or mental impairment that substantially limits a major life activity. They have to have a record or a history of such impairment, or they have to be regarded as being an individual with such impairment. So the first one, we see this kind of this allegation probably filed on most frequently of having that actual physical or mental impairment that substantially limits a major life activity. And this is something that a lot of different conditions certainly can qualify under this. It's not necessarily going to be I guess, a broad evaluation of, oh, well, this has, some substantial impact only on this specific area. That's the only ones that will qualify. No, that substantial impairment of a major life activity, that can be a wide range of things. So it could be that I'm substantially impaired in my ability to work. It may be that I have a substantial limitation in my mobility. It may be that I'm substantially limited in a bodily function as opposed to something that, is just obvious. Maybe it is that mental impairment that is, again, not something that's obvious, but it's something that does have a substantial limitation. So there's a lot of conditions that certainly can qualify as being a disability under the law, but it is something that we're going to look at specifically of, are they substantially limited in some sort of major life activity, and was the respondent aware of it? So if the respondent was not aware of one of those conditions, certainly that's going to be an aspect of the evaluation, is, was the respondent actually aware of a condition? A respondent doesn't have to have a specific diagnosis, and it can be something that maybe they have a broad knowledge of what the condition is, but they don't know what the specific condition is. They don't necessarily have to. If they are aware of the substantial limitations, or kind of their need for a reasonable accommodation, or they have a doctor's note that says, yes, they are a person with a disability under the Fair Housing Act and the North Dakota Human Rights Act, that may be enough, even if they don't know the specific condition. Having that record or a history of having such an impairment, maybe they aren't actively having limitations that are related to that condition, but they do have a history or record of having that impairment. That can certainly qualify them as being a person with a disability as well. Being regarded as, so this last element of it, this is going to be specifically for, basically, they don't have the condition necessarily, but they're being treated as if they did. So this is kind of that stereotype that maybe a respondent, maybe they have a family history of certain mental illnesses or physical disabilities, and the respondent just assumes that they do. So they treat them as if they do have one of those conditions. They can be what they call regarded as being an individual with a disability. When we do this evaluation, like I said, it is very fact and case specific. And it's really, I mean, we're looking very closely at what the condition is. There's going to be a lot of times, though, that the respondent may not necessarily dispute that the person is a person with a disability. So that's something that we oftentimes look at as well. But for the most part, this evaluation on whether or not a person with a disability can be, lengthy. It can just be very fact and case specific. So it can only be discrimination if that person has a disability, right? No, not necessarily. So it can certainly be because of the individual's disability themselves, but it can also be their association with a person with a disability. So maybe it's their husband or wife, it has the disability, and yet they believe that they're being discriminated against based on that person's disability. Or they have a right to be able to file basically in the impact that it caused them related to the condition or that treatment. So if the respondent is treating them differently because of that person's, spouse's disability, both the spouse and the both spouses, I guess, would be able to file a complaint if they so wished. It could also be maybe an individual, maybe they're having a visitor and they believe that they're being treated differently because of that individual's disability. So it doesn't necessarily have to be the person themselves that have the disability. Another kind of example that we talk about or think about is it could be what we call testing cases. So if you have an agency or an entity that is contacting businesses to see if they're within compliance of following the Fair Housing Act, following those fair housing guidelines, they could contact a respondent and say, I have 10 service animals. Can I rent from you? They could just be, they could be testing. They may not necessarily have a disability themselves. So disability discrimination can occur even if that individual themselves does not necessarily have a disability. And again, disabilities are going to be something that it's a broad spectrum. They're going to be things that are visibly obvious, and there's going to be a lot of disabilities that aren't. They're going to be things that maybe you can't see them. Maybe they're not even something that you necessarily think of. Heart disease, diabetes, HIV, all of those can be considered disabilities, and there's something that you wouldn't necessarily know that that individual has a disability. A lot of mental disabilities are going to be something that may not necessarily be visibly obvious. So, how does this affect you? How does it, what does it all mean for you? Well, as we talked about before, disability is by far the most filed on issue with our department, and it can be very overwhelming. Even for us investigators doing these investigations and evaluations, really disability is just kind of a beast as far as trying to figure out all the nuances too. So it's certainly not an easy evaluation. And so kind of walking through some of these actual examples of issues that we see, frequent issues that people encounter, hopefully it'll kind of loosen up just all the legal jargon of understanding what disability is, what kind of that legal analysis is. Again, when we talk about disability, most filed on issue within disability is going to be reasonable accommodation. So, reasonable accommodations, all that is a change, exception, or adjustment to a rule, policy, practice, or service. So, basically, reasonable accommodations are something that allow individuals with disability to have the same enjoyments and uses of the property as any other tenant or individual that, in those rentals and sales of the property. So, basically, it's to level the playing field, ensuring that all individuals that reside in those units are getting kind of equal access and enjoyment out of the property, regardless of their disability status. And we're talking about these exceptions. A lot of reasonable accommodations are going to be something that they may not necessarily cost anything because they truly are just kind of requests for exceptions to a rule or a policy because of that person's disability. And under the both the state and the federal fair housing laws, if you fail to engage in that interactive process, if you fail to provide a needed reasonable accommodation without some sort of kind of undue hardship or specific reasoning, it can certainly constitute discrimination on the basis of disability. So it's something we see most frequent. And I think one of the reasons it really is the hardest thing to tackle is because it absolutely is a case by case basis. You may have 100 individuals that have the exact same disability that may need 100 different reasonable accommodations because of their specific needs or how the disability impacts them. So it really is just, like I said, kind of a bear cat. It's a lot of difficult case by case evaluations that can be very daunting and intimidating to any landlord. So again, reasonable accommodations most commonly filed on issue with our department as well as with HUD. The requests can be made, they can be made from current or prospective applicants and residents. So obviously a lot of reasonable accommodations when you think of them or when we have that evaluation, they're going to be from tenants that are already living in the unit, but not always. It could be that maybe an individual is requesting some sort of accommodation to the application process itself. Maybe it is that they're just contacting you to ask about, whether or not they can have a service or assistance animal or something of the sort. The respondent has a legal obligation to address these requests in a timely manner. Under the federal law as well as state law, it's not a magic number. So there's not a, you have to respond within X amount of days or X amount of weeks, or you have to provide the accommodation. But we do look at the timeliness factor because, and what we call an untimely delay in providing that accommodation, then we can certainly evaluate that as being whether they should have provided it sooner or what was the delay? Why was there a delay? So if it's something that, let's say they asked for an exception to maybe like a rental policy where you have to put it in a green envelope and have to put it into the rental slot. And the individual asks for, hey, I am colorblind. I can't see the green envelope. I'm going to use a white envelope if that's fine. And the respondent takes 6 months to provide a response of whether or not they can or can't do that. That's going to be possibly an untimely delay, because what was the reasoning or necessity in that delay in process? Requests may impact the individual's residence as well as common areas. So it definitely is going to be something that they would evaluate, as far as, does it impact, obviously within their unit or those common areas. Maybe it's the common area and the place where, maybe it's like a meeting room, or maybe it's just the general hallways coming and going. So it's not always just going to be the individual's unit. Reasonable modifications, very similar to reasonable accommodations, but a little bit different in the fact that, um, they are going to be those structural changes. So those actual changes to the unit or the common areas for those individuals with disability. They're going to have that same kind of undue hardship test, which we'll talk about, but it's going to be, is it some sort of actual structural change that is needed for the disabilities or the disability related condition? So are there going to be changes? Maybe it's lifting and lowering a countertop, or maybe it's providing a ramp or something of the sort. So when we look at reasonable accommodations versus modifications, again, very similar, but the accommodations are going to be those alterations or changes to the rule, policy, practice, or service. When we look at reasonable accommodations, generally the costs are going to have to be paid by the landlord, regardless of whether it's a public or private unit. It's going to be something that most of the time there's not going to be any actual cost associated to it. So it's going to be something that there's likely not going to be a cost, but if there is any sort of cost, even let's say maybe they have to have some administrative paperwork or something of the sort that has some cost, so that those costs would have to be taken on by the landlord. Reasonable modifications, again, those are going to be those structural changes. So those removal of those physical barriers, those are going to be costs paid by the tenant. So in those cases, any of those changes to the unit itself, that cost would have to be paid for by the tenant in private situations. If they're under a federal supported program, then the landlord will have to pay for that. But outside of that, they're going to be, again, generally paid for by the tenant. And the landlord can request that the unit be basically returned to its initial or original condition. So those are things that upon leaving the unit or anything like that, they may have some costs associated to ensuring that the property is back to its original condition. When we're talking about accommodations and modifications, they do not need to be on a specific form or any sort of magic words. We have a lot of complaints that come through, and the respondent says, well, I have a reasonable accommodation form and I need them to fill that out. I need them to complete this in order to receive the accommodation. You can absolutely request the having the individual fill it out on paperwork, but it cannot be a condition of receiving a reasonable accommodation. So I always say it's kind of something that it can be very helpful for both parties to be able to kind of document and explain, this is the reasonable accommodation I'm requesting. This is why I need it. Just kind of setting the stages to, this is what's going on with the reasonable accommodation. I think that can be very helpful for both parties to be able to have that information. But it, again, can't be a condition of receiving that public assistance or that reasonable accommodation. When it comes to those reasonable accommodations, it could be that you know, they're asking for something maybe more broadly. They're saying, boy, because of my wheelchair, I really do think I need to be on a first floor unit, or, because of my condition, I need to have an assigned parking space because I just can't guarantee. Those aren't going to be something that's saying, I am a person with a disability under the law. I'm requesting a specific reasonable accommodation because of XYZ. It's not going to necessarily be in those really clear and concise, specific magic words. So sometimes it is going to be something that they're going to have to, really evaluate and look at what is this person asking for. Kind of looking for those reading between the lines, kind of those key indicators, and they they may not be as clear. So anybody who's dealing with the general public, you're going to want them to be able to kind of pick up on some of those. Hey, I think they may be requesting a reasonable accommodation. Working with tenants can usually go a long way. And we will talk about this a little bit more kind of in our advice going forward. But really, again, this is why having that documentation, the paperwork, everything, I really think that it's something that makes it easier as far as the tenant understands what you're asking for, what you're requesting, and why, and vice versa. It's not always going to fix all of the problems, but really working with each other on resolutions, I think can make it a lot easier for both parties to kind of know where they're at. It's again not always going to prevent everything, but at least having that baseline understanding between the parties definitely helps. So when we look at reasonable accommodations, reasonable modifications, well, what exactly is a reasonable? Something that might be reasonable for some the person might not be reasonable for another. So when we talk about what's reasonable, we're looking at kind of two main aspects of it. So does it constitute some sort of undue hardship? So is it a financial kind of substantial financial impact? Is it going to be something that interferes with the business operations? By allowing this or permitting this, is this changing the nature of which we do business? Is it changing how we operate? Those are going to be obviously something that would not necessarily be reasonable. These are things that we're going to look at very closely. So if they say, it's a reason, let's say in a situation they say, well, the person's asking for something that would cost us $100, and that's just undue hardship. That's a financial burden on us as an entity. But we get that evaluation. We say, okay, well, let's take a look at your finances, and it's a multi-million dollar business. Something like $100 might not necessarily be unreasonable, even though that's their defense. So if a landlord or a respondent does take the kind of unreasonable standard approach of saying, well, what they were asking for was unreasonable, we do look at this very closely and look at it on that case by case basis. Same with that, does interfering with those business operations. Are they going to have to financially, hire a new person to entirely operate this other piece of the business? They're going to have to completely change how they do business in order to provide this reasonable accommodation. Then that certainly may not be reasonable. This is the part where a lot of landlords really, it's a hot topic. It's something that can certainly be very touchy issue, and that's service and assistance animals. We see a lot of issues when it comes to service and assistance animals on both sides. We have a lot of tenants that request service and assistance animals, and maybe they don't provide proper documentation, or maybe they are not necessarily following kind of what the Fair Housing Act establishes of kind of how you ask for those or how you make those requests. Likewise, we see a lot of errors on the respondent side, where the respondent is kind of making those rash decisions or saying, no, absolutely not. We are a no pet property. We can't allow any sort of service or assistance animal. So it's very much a kind of a hot topic. It's something that we see a lot of issues with. So it's definitely something we want to talk about. So service and assistance animals, the individuals who are disabled may require the use of service and or assistance animals. So a tenant, even if they are living in a no pets property, they can request a reasonable accommodation, which is again that change or modification to a rule or a policy. And they can ask for kind of that exception to the no pets policy. So even if the unit itself, the property itself doesn't allow any animals, they may be requesting that exception to the rule because of their disability. And when a landlord receives those requests, they have to really evaluate them again on that case by case basis. And if they are going to deny the request, they have to have some kind of legal backing as to why. Again, is it something that's not reasonable? Is it not necessary? Is it going to cause that undue hardship on the landlord? So, there could be other aspects. It could be, is it a direct threat? Are there other aspects to it? But they have to be able to provide kind of that justification or backing in order to say no. Otherwise, it could certainly constitute a violation of a reasonable accommodation. There's going to be different types of assistive animals. So it's not always going to be, a cat or a dog. It certainly can be some of those, I guess, non-classical type animals. It could be reptiles, it could be birds. Excuse me, I'm coming off of a cold, so naturally I have the coughing attacks at the most opportune times. So when we're talking about those different types, again, reptiles, birds, it could be hamsters, guinea pigs, it could be, quite a variety of different types of animals. Fees or deposits can't be a condition of receiving an accommodation. So just as you wouldn't charge an individual an extra deposit or fee because they are, let's say, in a wheelchair or have a walker, you wouldn't do the same with somebody who has an assistive animal. The ones we think of the most is, yes, maybe we allow pets, but you have to have a pet deposit. If the individual has all the documentation, kind of the backing for a service and or assistance animal, it is not a pet. So it's not going to kind of fall under that same category as pet. So they are not going to be required to have the general kind of deposits or monthly fees that you would with individuals that have a pet. We get a lot of kind of arguments and issues with that. But again, kind of thinking of it as you wouldn't charge extra for an individual to have, again, some sort of assistive device for their wheelchair or their walker for their disability. You wouldn't do the same with that service or assistance animal. So HUD just made some changes. They did have quite a bit of guidance as far as some notices and some general guidance that they have since removed, it just within this last couple of months. Basically, it's a lot of the guidance really has been out there for a long time. And kind of HUD's reasoning is that instead of kind of acting as broad guidance, that they would look at things a little bit more case by case, just kind of those individual assessments. Unfortunately, a lot of the guidance, it's, again, the laws are so kind of hard to understand sometimes. There's legal jargon, even for people who do this on a daily basis. It's just very cumbersome. It's just very kind of tough to understand. Sometimes it's tough to figure out what it is they're exactly saying. So sometimes some of that kind of simplistic wording can be very helpful as far as giving you a little bit more information. So I would assume that they may have some other guidance that might come out in the future, hopefully, because I do, again, think it's just easier for normal people to be able to see kind of layman's terms on how to try to address some of these reasonable accommodation issues that just come up so frequently. So some of the common issues we see with relation specifically to service or assistance animals, we see direct threats. We'll talk a little bit more about direct threats, but the biggest thing with direct threats is it can't just be based on speculation. You really have to have some sort of reasoning or baseline as to why you're saying, for example, an animal is a direct threat. Saying, well, it's a certain type of breed, they have a likelihood of attacking small children or other people. that's not going to necessarily be enough to say it truly is a direct threat. If you have some sort of viable indication that they either this animal has a history of it, or it appears that, based on some sort of facts that you have, that this animal may be a direct threat, that certainly can be a defense as to why a request would be denied. But again, it's going to be something that's looked at pretty closely, and just having that broad, well, we figured it was a direct threat because of the type of animal it was, that may not necessarily be enough. City restrictions. We saw this one a lot. Kind of, there was a time where there was a number of different cities that were having certain breed bans, and the defense, at least for a landlord, isn't always going to be viable. That it's, well, we said no because we know it's against the city ordinance to allow said type of breed in town. That's going to be an issue that's within kind of the against the person, the individual who owns that animal, and the city. The respondent can't necessarily take the defense. Well, we said no because we know the city won't allow it. That's not going to, again, necessarily be a good defense. The tenant, the individual, certainly can file against the city if they believe that there is an exception for like a reasonable accommodation or something of a sort, because, hey, I need this specific animal for this specific reason, and there's no evaluation process on the city side. They can sure file against the city. But just the landlord having the defense that they can't have the animal because it's against city ordinances, that might not necessarily be something that would be permitted under our evaluation. Again, common areas. It can certainly impact the individual within their individual unit, but it also can impact those common areas. You're going to have situations where, let's say, if the individual has a dog, they may have to walk the dog through the common area, hallway, entryway, whatever the sort may be, and it certainly may impact those common areas. It can be just those general, again, common spaces, those areas where you're allowing tenants to utilize. And again, same kind of reasoning as sort of that pet deposit is, you can't limit an individual's ability to have the same enjoyments of the property because of their disability. Again, you're still going to have that kind of medical necessity piece, but those are all things that certainly can come into play. Having specific requirements of the animal. So again, having those kind of extra expectations that as a condition of receiving a reasonable accommodation may not be permissible. So having those specific, it has to be spayed or neutered, it has to be a certain kind of breed, or cannot be a certain kind of breed. It has weight limitations. Maybe it has to be, under 30 pounds or under 20 pounds. Those would be those additional conditions saying that, you have to meet these as a condition of receiving a reasonable accommodation. And that's just not something that generally under the reasonable accommodation laws you can do. You can't set those extra hurdles up, or, have those extra expectations for an individual with disabilities. That being said, so all of those, you can't, you can absolutely still have expectations of behavior. And that goes for the tenant as well as the animal itself. You can have expectations that the tenant, make sure that the animal is cleaned up after. You can ensure that the tenant is, handling the animal. So maybe while it's coming in and out of the unit, maintaining it on a leash or under control. As far as, barking nonstop or destroying property, those are all expectations of behavior that you still can have regardless of whether or not it's an assistance animal. So what if another tenant also has a disability, such as allergies, that won't allow for the service animal to be in the unit? This certainly is something that may come up. And unfortunately for a landlord, you may have to try to find a resolution that works with both parties. So we have basically what we call competing disabilities. So you're having two individuals who both have disabilities who are requesting reasonable accommodations in some capacity, you may have to try to find resolutions that would work with both parties. It could be maybe having them move units or having the individual with the animal only use a certain entry or exit or something of the sort. There could be certainly things that you may have to evaluate as far as trying to find reasonable accommodations that work for both parties. And it may be that there is not a reasonable accommodation. Maybe it is unreasonable. Maybe it's something that, you know, as short of building another building, there's just nothing you can do to resolve that issue. There certainly may be, again, situations where it is no longer reasonable, in which case, under the law, you can deny accommodations, but you really have to have kind of that legal backing as to the reasoning why. So this is a Century Code. It actually was changed just or added, I think, 2 sessions ago now. This is specifically related to documentation for service assistance animals. And basically what this legislation was for was trying to combat some of those just easy go online and you pay for the medical notes. You don't necessarily have to meet with a physician or a doctor. Just trying to get really that kind of validating the documentation piece for any documentation for a service or assistance animal. One thing that's very difficult in these types of evaluations or situations, especially kind of in the post-COVID era, is there are a lot of providers that do provide telehealth services, and they absolutely are just as valid, and they could certainly have the evaluation of that individual's health needs. They may understand what that person's condition is and be able to certify that based on their knowledge of this person's disability that they are in need of a service or assistance animal. So there may be situations where it is absolutely an online provider, but it's still just as valid of documentation. So it is something that it can be very much a fine line because it is so common anymore, that just the automatic, oh, well, they clearly just paid for this. It's sometimes there can be a little bit more to it. It can be a little bit deeper than that. So if that's kind of the reasoning for the denial or justification for the denial, you'll just want to evaluate it very closely to see, is this truly something that falls outside of the compliance of what's needed for that request for the reasonable accommodation? So, can requests be denied? Yes, absolutely. We talked obviously about those unreasonable requests, but there are going to be situations where, yes, a request can be denied for plenty of reasons. It could be that the request wasn't, maybe it wasn't made by somebody who actually is a person with a disability, or maybe there's no indication of what the medical related need for the accommodation or clarification to that medical need, and the individual won't provide that documentation or they won't provide that reasoning. Those could certainly be reasons why you may deny one as well. So again, undue hardship is one of the main reasons that we look at of, okay, it was an undue hardship. So did it impose that undue financial or administrative burden? Would making the accommodation or modification require a fundamental alteration to the nature of the provider's operations? So those are all going to be things that we would look at. Again, if the respondent chooses this as a defense, we're going to look at it pretty closely. It's not just going to be, oh, well, they said that it was an undue hardship, so therefore it's not a denied accommodation in violation of the law. We're going to obviously look at the reasoning behind it, kind of the backing behind why it's an undue hardship. Is it some sort of direct threat? Again, not looking at that kind of generalization or that speculation or fear stereotype behind something, really having some sort of reasoning as to why you believe that this animal is some sort of direct threat. So looking at the nature, duration, and severity of the risk of injury, the probability that injury will actually occur, and whether there are any reasonable accommodations that would eliminate the piece that is the direct threat. So, are there any other kind of aspects you could look at that, okay, well, we can provide it if we do X, Y, Z? Again, really with direct threat, it's not that you have to wait for something to actually occur in order to be able to take action, but you really do have to evaluate, kind of what's the reasoning behind why you believe it's some sort of direct threat. So, can a landlord ask for documentation regarding a disability, regarding the medical related need for the accommodation? The answer is maybe. So, yes and no. The landlord can certainly request additional information, additional clarification. They can request whether or not it's, let's say they need information of, is it necessary, that the medical necessity behind the reasonable accommodation? Do they need to understand, does the person have a disability? Again, they are not entitled to having to know what the specific diagnosis is, but they do need to have some sort of documentation or understanding of whether or not the person is a person with a disability. So it can be something as small as their doctor indicating on, a medical form or whatnot, saying, yes, we believe this individual is a person with a disability under the law. That can be enough to say, yes, they are a person with a disability. They don't necessarily need that documentation or, that additional information of whether or not they have a specific condition, what that condition is, but they can ask for that documentation indicating, yes, they are a person with a disability. They can ask again for documentation related to that medical necessity, especially in circumstances where it may not necessarily be clear of either, let's say, maybe it's a specific type of animal. So it's one of those kind of non-traditional, out of the norm animals that is needed for that disability. And it's not clear on the documentation why it has to be this specific animal, type of animal, whatever the case may be. Maybe it's something that there are a number of animals. So maybe this individual does need two dogs because of their disability. One of the dogs is to handle their anxiety, and the other animal is to alert them of kind of diabetic ebbs in their insulin levels. So they may have two different animals that provide two different pieces for their disability, but maybe the landlord needs documentation kind of indicating, why is there the need for the two? All the doctor's note says is, yes, they can have an animal, but you're telling me it needs to be two. Can you provide clarification? So there might be additional information that's needed to understand what the request is, to understand that medical necessity. So yes, you can ask for documentation, but the biggest thing to keep in mind is you are not the medical provider. So you shouldn't be asking all of this information of saying, yeah, but it's not clear. It says you're a person with a disability. It says you need XYZ accommodation, but in my opinion, it's just not clear on why you need it. You are not the medical provider, and really, if the information and documentation says what you need, generally speaking, that's all you can ask for. So again, if the documentation received for an accommodation request is not clear, you can ask for additional documentation that verifies the presence of the disability and or explains the specific connection. But again, you're not the doctor, you're not the medical provider. If they have that clear connection, that's really all you can ask for. Different types of accommodations. Obviously, service and assistance animals, something that we see quite frequently. It could be that they're requesting a ground floor unit. Maybe they're requesting an assigned parking space or a closer parking space to the building because of their disability. Maybe, again, the modification to the method of rent payment. Maybe the requirement is to provide a paper check or to provide online payment. And because of that person's disability, they have a need to provide it in an alternative form. That could certainly be potentially a reasonable accommodation request. And that's if they have that medical tie, maybe it is due to their vision, they're unable to process those online payments. So the landlord works with them to provide a written payment, or maybe they provide them assistance in providing the payment online so that the individual can still be able to provide that payment. Maybe limitations on certain scented products. Maybe it's cleaning products or air freshener products, or general products that are used in those main areas. And due to an individual's disabilities, maybe they have sensitivities to that due to their asthma or COPD. They're unable to have those used near their unit. That could be a request for reasonable accommodation. It could be a change to maybe the type of living situation they're in. Maybe due to their disability, they do need a smaller or a bigger unit. And so their request might be, I would request to basically be removed from my current lease for unit 201 and be moved to unit 202 because it is a bigger space or a smaller space, and that's needed for my disability. So those all might be examples of reasonable accommodations. Big things to keep in mind is, again, obviously the request itself might not be in that clear and concise statement. So making sure to understand kind of those indicators or those triggers of, it sounds like this person is requesting reasonable accommodation. I'm going to start that back and forth, that interactive process with them. Respond promptly. So those undue delays might be deemed as a failure to provide an accommodation, especially if they were unnecessary. If there was really no reasoning as to why there was such a delay, that could be problematic. Think about dance with reasonableness. So you're looking at, does the person have a disability? So disabilities being the D in dance. A for accommodation. Is the tenant requesting a change to the landlord's rules or practice? Is it necessary? So is the accommodation or modification necessary for the full use and enjoyment of the property? Cost. Does the accommodation or modification impose some sort of undue administrative or financial cost to the landlord? And then lastly, effect. Would the accommodation or modification affect a fundamental change in the alteration of the business? And so even if there's yes to those pieces, then you still may have to evaluate what are other options potentially. It may not necessarily be the accommodation of the individual's choosing, but it does have to be an effective accommodation. And as soon as you determine a request is being made, listen and take notes. So make sure you're understanding what's being asked. Again, this is where you can't require them to complete a form, but sometimes really working through that process together with the tenant will go a long way in understanding what's going on with what the request is, what the need is, all of those pieces. As our second most filed on issue, we'll talk a little bit about retaliation. So this is just the dictionary definition of retaliation, the action of harming someone because they have harmed oneself, revenge. When we talk about retaliation, it's not necessarily that the individual is blatantly intending to retaliate against the person. So it's not always that, oh, well, everyone knows retaliation is illegal. Why would they do that? It can be that they just kind of self-preserve. They believe that these allegations against them are malicious, or they're just kind of trying to kind of protect themselves because they do not believe that they are true, and they are just defending themselves. The accusations can be very serious. You don't see it as bullying sometimes as retaliation. So maybe the individual had made some allegations against a landlord and the landlord's upset by it. So they go, you know what, we don't want them living here anymore. We issue them non-renewal notice. Maybe we issue them, violations or tenant notices because of actions. It can certainly be deemed as retaliatory if it was in connection with them filing the complaint, or really if there was really no justification or reasoning behind it. One of the other aspects that we see quite frequently within our complaints is what we call publication. So we get a lot of complaints of discriminatory statements or advertisements, which basically means that the landlord, whoever is making the statement or printing or publishing of the issue, is indicating some sort of limitation or preference based on a person's protected category. So, kind of what the law is under the Housing Discrimination Act is a person may not make, print, or publish or affect the making, printing, or publishing of a notice, statement, or advertisement that is about the sale or rental of a dwelling and indicates any preference, limitation, or discrimination because of a person's membership in a protected category. So, examples of publication. Obviously, there's ones that are pretty, easy to think of. Newspaper ads, maybe they're those ads in some sort of listing or on the internet. They might be some ads on the radio. But they can also just be general statements. It can be that the landlord made a statement to a tenant. It could be a Facebook post. It could be a text message or a voicemail that's indicating a specific preference or limitation. Um, it's not always going to be ill-intentioned, but it can show a preference or limitation. So it could be that they're just basing the comment on past experiences, past situations, and they believe that there's no ill will behind what they're saying. They're just saying, I would never rent to a single male bachelor again. I've just had bad experiences. I will always decline bachelor single male applications every time I get them. Again, it could be that they just had a bad experience one time, but it can certainly still be a violation of law if they are indicating that preference or limitation based on a protected category. So again, they may not always be, the statements may be well intentioned, but not necessarily legal. Again, those same kind of exceptions, kind of exemptions from the rule, so exemptions from the publications rules, housing for older persons, those private clubs, religious organizations, shared living housing. So it could be that maybe it's a dorm situation and they're all females in this dorm. They can certainly have some of those limitations, those exceptions from the rule. But generally speaking, those publications, we're going to be looking at them closely of, is it going to be indicating some sort of preference or limitation based on that protected category? When we look at whether or not it kind of constitutes a violation, we have to look at what we call the reasonable person standard. So this means that liability is incurred by a person or entity if they make a publication or statement that indicates a preference and that the preference is readily apparent to an ordinary reader or listener. The one thing about this is it's not going to be, boy, because of my background knowledge of housing discrimination, I certainly think that you could constitute that being a violation. It has to be an ordinary reader or listener. So if an average ordinary reader or listener were to read or listen to that statement, would they gather that it is indicating some sort of limitation or preference based on a protected category? That's what we're looking at. We're not looking, a reasonable or ordinary person is not going to necessarily be the most suspicious. They're not going to, have this really high legal authority or assessment level. That's kind of what we're looking at. We're just looking at the average person standard of, if somebody were to hear this, would they think that this is going to indicate some sort of preference? Some of the terms to avoid when we come to these statements, these advertisements, adult, bachelor, couple, family, mature, no children, one person, retired, sex, single, two people, Christian, executive, exclusive, handicap, integrated, membership, approval, mentally ill, religious landmark, older person, senior citizens, physically fit person, race, restricted senior discount. Really anything that we look at, we're looking at, please describe the unit, not the tenants you want in the unit. So again, really looking at what was said. Would an average or reasonable person believe that whatever was said or printed, does that indicate your preference of in some way, or saying we don't want a certain protected category in our units? So really always keeping in mind kind of, again, describes the property, not the people you want in it. So kind of lastly, what we'll talk a little bit about is what happens? So if a complaint is filed, especially if you've never had a complaint filed against you in the past or kind of ever been through this process, it can seem extremely daunting, whether it's on the landlord end of things or the complainant's end of things. It can be a very overwhelming process because it is a very legal process. I mean, that really is what it is. The whole process that we deal with and handle is a legal process. So it can be very overwhelming for any person to go through on both sides of it. So we'll talk a little bit about what that looks like, just to give you an idea of kind of how we do these evaluations and investigations. So the first step is always an intake is filed. So anyone that lives, that has any sort of housing transaction that's under the law within the state, they have a right to file. So they can file a complaint with our department, and that's pretty much the first step in any part of the process. So the intake is going to basically have them explain and summarize what happened. How do they believe that they were discriminated against? When did the discrimination occur? Where was the discrimination occurring? Where was the unit? Who is the owner of the unit? So kind of that general information, just what you would think of with like an application or, a general intake inquiry form. It's just asking for those general pieces so we can kind of start the evaluation on, do we have jurisdiction? Can we move forward with this complaint? So that's what the next step is. Once we receive that intake form, it's assigned to one of our housing investigators, and then it's up to the housing investigator to really do that initial evaluation of, okay, so what they're alleging does fall within the compliance of the law. So it is a housing related transaction. It is a covered entity. So it's, more than that singular unit or more than those 4 units. It's not under one of those exemptions. And looking at the statute of limitations is a big one as well. So the statute of limitations, or kind of that look back period that we can look for in complaints, is 1 year from the last date of harm. And so they have 1 year to file from whatever occurred happened. So if they were to file today, then they would file the complaint and have to sign it, basically to start the process, sign the formal complaint. They'd have to do that by today. We could look back 1 year from today. So that's kind of what we're looking at for that statute of limitations. And once we establish that jurisdiction, we say, yep, what they're alleging is allegations of discrimination based on a protected category. We do have authority to move forward with the complaint, all of those aspects. Then the investigator would draft kind of it's a complaint is what it is, but it's a summary of the allegation. So you may have an intake that is 20 or 30 pages of, narrative and background information, but really the allegation itself is, I believe I was issued a non-renewal notice because of my race. And so the complaint is really just a summary of what's being alleged. So what discrimination they're alleging occurred based on a protected category. And then once they file that, or once we put that summary together, we send that to them for their review. It's going to be truly a complaint form. So it says who's the aggrieved party, who's the respondent, what are they alleging, and on the bottom of that form we'll have a signature line and date line, and then we send it to the complainant to review to see if everything's accurate and correct. If it is and they wish to file, then they sign that complaint and send it back to us. And once we receive the signed complaint, that is what officially opens the complaint with our department. So we open the complaint, and then that's when we send it on to the respondent and request their side of things. So we request a response to the allegations. Once we receive that response, then that's where the investigation begins. So we do kind of go through all of the pieces of information. So all the information that the respondent provided, all the information the complainant provided, we do additional interviews with the parties. So we may interview the respondent, the complainant, any additional witnesses, any additional parties that may be relevant. We may ask for additional documentation or information, additional comparative data. So who else has been issued non-renewal notices? Who else has been issued eviction notices? All of those pieces are aspects that we look at in the investigation. And ultimately, what the investigator is looking to do is, once they have all the facts and evidence that they believe they need in order to make a conclusion on did a violation of law occur or not, then that's kind of when the investigation's completed and they issue what we call a determination. All the determination is, it's just a written report of our findings. So it explains whether we believe a violation occurred or not, and explains exactly how we came to that conclusion. One thing, and we'll talk a little bit about it here on the next slide, but conciliation is something that's emphasized throughout the process. So from the time the complaint is signed and sent back to us, so it's officially opened with our department, we always emphasize conciliation between the parties throughout that entirety of the process. Basically, it's a way for the parties to try to come to some sort of resolution amongst themselves prior to us completing the investigation. So it really is, in my opinion, it's a great way for the parties to just try to come to some sort of resolution and have a real say in the outcome, because otherwise, once we move forward with the investigation and issue that determination, all it is based on the facts and evidence compared to the law. So conciliation, it's just informal negotiations or resolutions that are passed back and forth between the parties in hopes to resolve the issues prior to the completion of an investigation. So it's between the aggrieved persons and the respondents, with the department acting as the mediator, the conciliator, kind of the middleman, passing offers back and forth. Any sort of conciliation, it is confidential. So the parties, any of that information is confidential and kept within the conciliation itself. But one of the things about a conciliation, again, it's a great way for the parties to have a say in the outcome. But if we do have parties that come to some kind of resolutions, then they would have what we call a conciliation agreement, conciliated settlement agreement. And what that agreement is, it just outlines what's being agreed upon. So there's always going to be an aspect of what we call relief for the complainant, and then relief for the public interest. And relief for the public interest, that's going to be basically ensuring that we are kind of expanding the knowledge and understanding of fair housing laws. So it could be that the respondent is going to review and update their reasonable accommodation policy. Maybe they're going to take a fair housing training. Maybe they are going to distribute fair housing brochures. Again, it's basically something that's just kind of furthering the knowledge of the fair housing laws. And then the relief for the complainant, again, a variety of things. Really, the options are kind of endless. It could be something like when we think of commonly, maybe a financial piece. So maybe it's some sort of financial compensation, but it can be a wide variety of other things. It could be that they're requesting to be released from their lease without penalty. It could be that they are requesting their reasonable accommodation to be granted. It could be that they are requesting to have a positive rental referral. Or maybe it's that they are just requesting to move to a different building. It could be really, options are endless. There's a lot of different resolutions that we see, different types of resolutions that we see between the parties. But those ultimately, once we come to agreement on those terms, then we would have that binding agreement between the parties. The parties would sign off on it. And really, throughout the whole process, even though it's something that's emphasized, and we certainly, you'll kind of hear us talk about it a lot, of at any point you guys can present any sort of offers. Would you guys like to make any offers? We received this offer, we're passing it along. They're absolutely voluntary. So both parties absolutely have to be willing to participate in that process. It's not something that's required of either party, but it is, again, I always am a huge proponent of it, because at the end of the day, it really can hopefully come to resolutions, as opposed to just moving forward and coming out with the determination of saying, yes, we believe a violation occurred or not. When we do make that determination, so if based on the facts and evidence, we do believe a violation of the law occurred, then we issue what we call a charge. So it's just that legal charge document. It basically indicates that we believe that there's reasonable cause that a violation occurred. And when we issue that determination, that charge, really the options going forward from there are court options. So district court or an administrative hearing. So which is similar to district court, but it's one-on-one with an administrative law judge. If we believe that a violation of the law did not occur, then we issue out that determination saying, no, we do not believe a violation of the law occurred, and the case would be closed with our department. We would dismiss the case. There are court options that they could always pursue the issue through court, but generally speaking, the department would close their case and dismiss it if we do not believe a violation of the law occurred. Again, role of the investigator for our department, we're there to conduct those fair, impartial, and thorough investigations. We're always going to be that neutral party. So we're not on either party's behalf. We're just evaluating the facts and evidence compared to the law. So ultimately, we are just making that determination: is there reasonable cause to believe that the respondent committed an unlawful act of housing discrimination or not? And that's kind of how the conclusion we come to, that's how we're going about it. So kind of biggest recommendations going forward, obviously doing things like this, going to these presentations, taking advantage of any sort of trainings, I think always will benefit you. It's always going to provide you additional information, even if it's just as small as, you're sitting in a situation and you go, boy, I remember talking about something at this fair housing training. I think I need to talk to somebody about this or look into it before I say yes or no. Even just those small things, I think getting educated on the fair housing laws and understanding what they are certainly will help you a lot in any of those decisions. Looking at our website, going to HUD's website, just trying to find any of those resources that are out there. As all of us know, the internet can be a great helpful tool. It can also be problematic at times, but there's so much information out there, a lot of information about fair housing laws, and it can certainly help kind of point you in the right direction. But ultimately, if you are not sure what to do with a specific situation, you're not sure what is within compliance or not, the best thing that you're going to be able to do is speak with an attorney that's knowledgeable in fair housing laws. You may have a wonderful, family attorney, family law attorney, divorce attorney, but talking with somebody who has experience and knowledge in those fair housing laws is always going to be something that will be helpful in making sure you get the right answer, especially when it comes to those case specific questions. Other things to kind of keep in mind: document everything. One of our sayings always, whether it's for the wage and hour side of things or the discrimination side of things, if everyone documented well, our jobs would be so much easier. In a day and age where documentation is so easy to come by, it is very easy to, be able to document those memos, those emails, any of that correspondence. It can always be very helpful in being able to make that ultimate decision of, okay, this is why we made the decision that we did. This is the documentation we have behind it. It can absolutely help you in these types of investigations because, again, they can be difficult. They can be really, lot of factors that go into it. And if a complaint is filed, documentation is going to be your best friend in being able to explain what happened, why it happened, what was occurring. So documenting everything is ideal. Avoid sudden or rash decisions. So take your time to think through and evaluate the request prior to jumping to conclusions and saying no. This goes a lot for a lot of those reasonable accommodation requests you get. You get a reasonable accommodation request and you're going, that's just asinine. We would never do that. Absolutely not. Without understanding more about the accommodation request, what that medical need is, having that instant response of no might be problematic. So really taking the time to understand what the person's asking for, what their reasoning is, what the medical documentation is showing, those sudden rash decisions can certainly pose problems for respondents. Train your managers and staff, especially with those that are dealing directly with the public. You may have managers, landlords, property managers that are fantastic and they do everything by the book, right? Exactly how you wish for them to do it. But you have, an office manager who's the one answering the phones when these property managers are out of the office. If that individual isn't sure what to do or say in those situations, even though they may not have been the person normally on phones or normally responding to those requests, if they have the capacity or power to make those decisions or are providing responses to the public, you really want to make sure that you just give them a general knowledge on some of these fair housing laws just to prevent any issues from occurring. Know the law. And if you do not know what the law is, make sure you contact an attorney. It's always so tough because the department gets a lot of phone calls from landlords and from tenants saying, hey, this is my specific situation. What am I supposed to do? The department cannot provide any sort of advice or guidance. And I know just firsthand from past work experiences, I know how tough that is because you're contacting the enforcement agency, the people who will tell you if it's right or wrong, but ultimately they can't provide that answer just over the phone before something happens. And the reason for that is there's just so many details that go into these illegal evaluations that one factor, even just so small or so slight, the either party may go, well, I didn't think I needed to include that information because it wasn't relevant or it wasn't necessary. And it can absolutely change the outcome or evaluation of a case. So when we're telling you we can't provide any sort of advice or guidance, it can be tough to hear. But if you know a specific situation you're in and you really need that, am I doing the right thing or not answer, go to an attorney. Our department will always point you in the right direction of here's where the law is, this is what the law says. But those really case specific questions, really contacting an attorney will be very helpful. Being consistent. This goes for not only making consistent decisions, as far as making sure you're not treating other individuals differently, based on some sort of protected category, but it also is going to flag for you in your head when something's not going right or normal. So if you are doing things consistently, you have a consistent routine, you're not straying from that. When something comes up that's out of the norm, it will absolutely stick out like a sore thumb. You will see or feel that there is something different about this, and you'll be able to see that and understand what's going on. But the biggest thing is just to make sure you're treating all of the tenants equally and consistently. It's not always that we see landlords it's not that they're doing the wrong thing. They may be trying to help somebody out, but when you start going down that path of helping some individuals out and not others, you really do open that door for, that kind of unfavorable or unfair treatment based on certain protected categories. And the last one, be nice. We do not get any complaints with our department that explain how wonderful of a landlord they have and how wonderful of a living situation they're in, but they just felt like they needed to file against the landlord. We have a lot of people that are very upset. They feel that they've been slighted or that they're being treated unfairly. And a lot of it does just sometimes come down to communication, that the parties just really have not communicated or understood each other on what's being expected, what's being asked for. Um, it's not always going to fix everything. You're still going to have complaints that are filed, even if you've been the nicest and most compassionate landlord. But just like I said, having kind of that understanding between parties and explaining why situations are being handled certain ways, it certainly can help some of these situations of individuals understanding why decisions were being made that the way that they were. So really being nice and trying to have that communication with your tenants can certainly go a long way. So with that, this is our website, phone number, contact information. You again, absolutely reach out to us. I can speak for every single one of our investigators and staff. We are all very much there to try to be helpful, to try to point you in the right direction. We understand how frustrating it is that we can't give you yes or no answers to specific case questions, but we really are there to try to be helpful, and really try to be pleasant. Nobody wants a discrimination complaint filed with them, but the department is really just there to evaluate those facts and evidence to determine if a violation happened. So certainly reach out to us along the way if you do have any questions.
Anyone have any questions?
Either I put them all to sleep or it was that good that they didn't even have questions.
Just so you know, this is one of our bigger presentations. We had 116 people on at one point.
That is quite a bit.
So, um, let's see. No questions. You did great. It was that good. The training was really good. Thank you so much. So, yeah, like she said, if you have questions, reach out. There's an email address and phone number. Thank you, Kiersten, again for presenting to our group. We always appreciate it. And again, for those that are still on, please be on the lookout for the survey that will be sent out. And oh, there's a question. Are there frequent updates to the state protected classes?
There has not been. So the last one was not this last session, but the session before, and that was just that domestic violence one, which, like I said, is a very limited category just because of that piece that says the state programs. But outside of that, we really hadn't had any changes. Ooh, it had been decades almost, since we had the last update or change to any of the protected categories. But the most recent one was 2 sessions ago, and that was that victims of domestic violence.
So if a landlord is reacting to a tenant because they just don't like them, that wouldn't be a fair housing issue?
No, we get a lot of questions. So, not as much necessarily. I mean, we do get some of those of, hey, they don't like me, they're treating me unfairly because of XYZ reason that's not a protected category. No, that's not going to be something that we have authority over. The other one that we see a lot of questions and a lot of complaints filed with, and it can fall under our protected categories, but generally it does not. And those are landlord-tenant issues. So those repairs or certain living conditions, like right on that cusp of cold weather when they maybe didn't turn the heat on, or when it starts getting warmer and they haven't turned the air on, those are really more landlord tenant issues because they're kind of unhappy with the living conditions, but not necessarily based on a protected category. And so those are going to be pieces that we aren't going to have authority over. And with the exception of really an attorney, there's kind of a gray area of who does handle some of those issues, because a lot of those are just under the umbrella of being a landlord tenant law, but there's not necessarily an agency that specifically handles only landlord tenant issues.
Is there a consequence of a landlord property management that gets a certain amount of complaints, whether or not they're consolidated?
What was the question again?
Is there a consequence of a
Oh,
landlord property management that gets a certain amount of complaints, whether or not they are consolidated?
nope, not necessarily. So it can certainly go to, I guess, damages potentially, like in a court setting. The thing is the department, it's kind of an odd connection or relationship between us and the courts because we are obviously evaluating the facts and evidence and making a decision if a violation of the law occurred, but we are not specifically, we don't have the ability to specifically award damages or, yes, because of this situation, this is what this person should be asking for or be owed. We don't have that ability. So it's something that a judge in kind of that evaluation of damages would absolutely assess and look at. But we don't have a specific like penalty wages or something or penalty pieces to our Housing Discrimination Act. We do under our wage and hour. So if a number of wage claims are filed against one specific employer, the penalty wages can increase for subsequent cause findings or we determine that they have not been paying their employees properly, but we don't have something like that for um, any housing discrimination. And I will say, obviously, large property entities, we may see more cases filed as a whole, but since I've been doing housing discrimination work, it really we see all types. I mean, it really is not consistent. We don't see, I mean, I almost never even see some of the same or similar like building, like community, let alone the same building, but we don't see too often of those. We may see a few cases of a specific entity that might be a really large entity. But outside of that, it's no different than, we may see a number of like Walmart cases. Well, it's because they have so many different locations and employees, not necessarily because of specific concerns, but it just depends.
Is it legal for a landlord to say we just don't take vouchers if the apartments are in the payment standard?
It depends. Obviously, that can certainly fall within the scope of potentially a discriminatory statement issue, but it's really going to depend on how it's worded, kind of what their consistent practice is, like how they're looking at it, as to whether or not that's showing a preference or a limitation because of a protected category. Because especially with public assistance, there may be certainly reasons why an entity may not, maybe they don't participate in a certain program because of the administrative burden behind it or because of some specific reasoning. But that's something that we would look at kind of that case by case basis of how is their policy or what their statement is, how is it worded, would it constitute a limitation based on a protected category? All of those things would go into it.
How long is the turnaround right now to start a complaint, and when should they receive a mail statement to sign?
So we actually work through them fairly quickly. I would say it depends too. I mean, if sometimes we have cases that once we get that intake, it has all the information we need. We're able to pull up because we have a kind of a as you've heard from all of our process, it's very legal, but we have to legally name the right respondents and everything. We have to do a property tax search to find out who actually owns the property. So it could be ABC Company is the one that manages the building, but John Doe is actually the person who owns it. Both of those people have to be named, even though Joe John Doe may go, I don't know what they were doing. The company was handling it. They still own the property, so they can still be named as a respondent. So sometimes that process, as much as I would like to say it's not too bad, it trying to do some of that property tax lookup can be very extensive. Sometimes there might be some real odd nuances to a case that you're really trying to kind of work through. Maybe you need to have advice or guidance from the commissioner or the human rights director, or even maybe the attorney general's office. But generally speaking, once we receive an intake, like the actual form itself, usually a complaint is sent out for the person to sign within 30 days at the most. Sometimes it's within a couple of days, sometimes within a couple of weeks, but generally it's within 30 days. Our case closure timelines, we have a requirement kind of with HUD that if we do not close a case, so once the complaint is signed and we receive it, that's that opening date, so that initial start date, 100 days thereafter, we have to either have resolved the case, or if we have not resolved it, so if there's ongoing conciliation or ongoing investigation, we have to send a letter out to the parties explaining why we have not resolved the case yet. Same goes with after 365 days. So after 1 year, we have to send a letter out also if the case has still not been resolved, explaining why the case has not been resolved, what's going on with the case. So those are kind of our general timelines for an actual case closure, but usually the complaint is sent out to the parties within 30 days.
And then, is there a penalty for the landlord slash property management to not respond to a claim?
Yes, we do obviously require, because it's both sides. We have to hear both sides to be able to understand and make a finding. If we do not receive responses, then we have to subpoena those. So we have to go through the subpoena process. A subpoena would have to be served on the person. And if the person does not respond to that served subpoena, then we take the legal steps to enforce the subpoena.
Any more questions? Does not appear to be. So I think with that, we will wrap it up. And next, for those that are still on, next week, our last session is on all the things Medicaid. So if you're interested about Medicaid, please join. And then we will be done until the spring. So thank you all for attending today's session. Thank you again, Kiersten, and hope everybody has a wonderful day.
Thanks, guys.